Let's bring in our guest. Joining us to discuss is criminal defense attorney, former prosecutor David Bruno. First and foremost, I want to talk about the family. That kind of made the news. That was the big news today. And it was actually two families. The families were split. The Goncalves and the Kernodle family not happy with the way this went down. They wanted a trial and the death penalty. And the Chapin and Mogen families were okay with it. They felt this spared them the struggle and the problems of a trial and the difficulty of going through that. What do you make of the comments by the Goncalves family?
Well, on the Goncalves family, they also say that they were not told about the plea agreement, Michael. And that is one of the most egregious, unethical things I've heard from prosecutors. Look, as prosecutors, you're not always going to make the victims happy with the plea dispositions. Plea negotiation always gives something up. Right? Prosecutors, they could either just go through the death penalty, but there were benefits for not only the government, but for victims and witnesses. There was no trial. He waived his right to appeal. This is over, and he's going to get consecutive sentences. But the reports have been that the prosecutor's office did not communicate that to the family, and that they found out watching the news reports on the breaking news. So if that's true, that is egregious. I mean, there's the Bill of Rights for victims. They should be at least told. They may not agree with it, but they should be told, and they certainly should not be learning of it while watching the news.
Yeah, there were conflicting reports. I believe the Mogen family said that it was in the air. There had been some suggestions, but certainly the fact that it had been something they finally decided on was not communicated to them, and they did find out exactly, as you said, through sort of public reports or social media or whatever. One of the interesting things about this particular plea deal is when you look at this case, we know that pleas are a necessary part of the system. The system couldn't function without plea deals. But you look at a case like this, and you look at the particular facts of this case, the way he sort of hunted these folks. Looks like he decided to kill them, but you don't really have any reason why he chose these young people to kill. He hunted, killed them. Seemed like they had a strong case. The evidence seemed to be mounting. If not the death penalty in this particular case, then when would you use the death penalty? Was this the right choice by prosecutors?
Ooh, great points, Michael, because in this jurisdiction, at the time of the plea, the court looked to the prosecutor to give a narrative of the evidence that they were going to prove at trial. And that was a pre-written statement that the prosecutor read off. And it took a long time, Michael, because it laid out the knife sheath and that it was found under one of the bodies, and it had his DNA on the buckle. Also laid out that, you know, he was stalking the area. And for the first time, Michael, I learned that they had his vehicle on video speeding away from the crime scene, almost swerving and getting into an accident while navigating a turn, and how that phone was off, and how it came on back on the network later, even before he got home. And we have heard about that selfie, too. Shortly after killing these 4 people, he goes and takes a selfie of himself with a big smile. And the narrative and the evidence that was purported today by this prosecutor left little to no questions about whether or not they were going to secure this verdict. So it really comes down to a question of, was it right, life in prison versus death? And luckily, I wasn't one of the ones that had to make that decision.
Yeah, it was definitely a difficult decision. And as we said, it split the family, split the community as well. We heard from the Goncalves family. Let's hear from the Mogen family. They gave a statement after this decision came down and he agreed to this plea deal. Let's take a listen.
I will be reading a statement of gratitude today from the Laramies. 962 days ago, we lost our Maddie, our kind, loving, vivacious, and caring daughter full of purpose and promise. We support the plea agreement 100%. While we know there are some who do not support it, we ask that they respect our belief that this is the best outcome possible for the victims, their families, and the state of Idaho.
And again, one of the questions was going into today's hearing could the families in fact block this? It turns out they didn't have the power. We know across the country there's been more of an emphasis on victims' rights. There's a Victims' Bill of Rights that's followed by most states. Were you surprised the victims didn't have more say in this situation?
Well, look, I mean, the judge started today's proceeding with essentially a constitutional law class on the separation of powers, letting everybody know first that he was receiving text messages and emails and all kinds of communications to his personnel and to chambers about, the objection of the plea. And he let everybody know at the very beginning, number one, they hadn't read any of that, and it was all forwarded either to security or to the police, but that he did not have that particular decision to say, I'm rejecting this because I want the death penalty. That's not what the court's authority was. The authority was essentially it could reject, but he couldn't reject it for that reason. And even before he even started the plea colloquy, the factual basis, and getting to the constitutional rights, he let everybody know the limitations of the judiciary versus the executive branch, and that the executive branch is the one that sets down the pleas and what the appropriate dispositions were.
All right, bring back in criminal defense attorney, former prosecutor David Bruno. And David, I got to say, when word came out that a deal had been reached and they were going to take the death penalty off the table, first thing that ran to my mind was, even though we had heard a building case that seemed very strong, I thought maybe there were some weaknesses in the case we didn't know about, and that's why they decided to take this route. But as he laid out the case there in court for the judge, it became clear to me that the case was exactly what we thought it was. It was strong. So again, it just goes to the idea of what a shock it was that this came down pretty much, as far as a lot of people were concerned, not only the family, but the public as well, that this came down as a surprise.
Strong, Michael. I mean, to say the least. I mean, you have his DNA on the K-bar knife sheath that was found underneath the two girls up on the third floor. And they also had his Amazon history that he purchased that particular knife. Just if you had that alone, Michael, you could prove the case. Then on top of that, you have the surveillance video, you have his car in the area, you have all the other things that are circumstantial that could just lay on top of the forensics that they had in the case. They had it. So it becomes a conversation about what is the appropriate disposition for the community, for the families, and bringing finality, because I do not believe there were specific legal issues that were going to be exploited by this defense that were going to lead to an acquittal like we saw today from Mr. Combs.
Yeah, and leading up to the case, we know that they were cut off from arguing any kind of third-party responsibility for this crime. So their case had been sort of undercut, the legs cut right out from under them. And you mentioned the community. The judge also referenced the community because a lot of this community was not happy with the decision to decide on a plea deal and take the death penalty off the table. And he referenced it when he was speaking to the court early on. Let's take a listen.
The court is not supposed to, and this court will never, take into account public sentiment in making an opinion regarding its judicial decisions in cases. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. If it were to reject this plea agreement, cannot force the state to seek the death penalty.
Again, the judge decided to take that road, David Bruno, but I think what bothers people, still eats at me, I'm sure eats at the family much, much more, is that we don't have answers here. We don't necessarily have a motive. We don't really know about a connection. We don't know why. You think there's any chance at sentencing we may get some of those answers? Will this guy speak up in court, give this family some closure?
Wow, you're right, Michael, because even the clip that we just listened to, right? The prosecutor said that he went up to the third floor and killed the girls first, and that he came down or was leaving, meaning that it could have been possible that he came in to target either one or both of the women up top on the third floor. That didn't come out today. And there was an opportunity for the prosecutor to quell these questions today in that statement. You know, we don't have that particular proffer in New Jersey. We don't hear from prosecutors like the way that we did today. That was his opportunity to lay out the narrative that could give the community, the family, some answers to these questions as to why. I think it's very unlikely we're going to get it from Kohberger, although he could speak up. But I just wonder, is the prosecutor going to come up and speak on this? They could have done it today. They could have embedded that information in the narrative that they said on the record in open court for everybody that was watching to answer that question. So will we get that in the sentencing? It could come from the prosecutor in the course of their arguments, or it could come from Kohberger himself if he chooses to give a statement. But we do not have those answers yet.
No, we don't, and I too was surprised. I thought there'd be a little bit more in terms of their theory of the case of why and what they had come up with. We know they don't have to prove motive, but I'm sure they have some idea of why this happened. But let's talk about Kohberger, because we talk about whether he's going to speak. I mean, just listening to him today, it was chilling to see the way he was responding to questions. You killed a human being, Xana Kernodle. You killed a human being, Ethan Chapin, and on with the 4 co-eds at this particular school. No emotion from this man. What was your reaction to that?
Yeah, to your point, very direct. In fact, Michael, there was a stipulation of a factual basis, which you don't see often. Oftentimes, there's a record made of the defense attorney asking their client the questions that would suffice for the factual basis that's required at the time of the plea. Essentially, the defendant has to go under oath and admit to each and every element of each and every crime, which he did, but he did it with a leading question with the yes, 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 and there was also that stipulation that the court read from. Right? So it wasn't the questions from the defense, and sometimes the prosecutor gets to ask questions too, in the form of questions that go to the foundation of knowledge, awareness, and voluntariness. So we didn't see any of that. But on the question of whether he's going to speak, now, generally speaking, usually defendants have appeal rights that they have to worry about. So they don't give statements, because who knows what's going to happen up at the next level of the appellate division if it's reversed. So oftentimes we don't hear statements because of that reason. But that's not a reason on this one, Michael, because part of his plea, he gave up his appeal rights. He can't appeal the sentence, and he cannot appeal any pretrial motions. So he could if he wanted to.
Yeah, he certainly could. And, you know, we heard in the P. Diddy case, it was a big victory for the defense. I want to ask you, are there any winners here in this case?
No, unfortunately, there aren't. You know, the family, you could see there's a split in the families. They've been traumatized. Not only, I could only imagine getting a phone call that your child is murdered at college where they should be learning, right? Taken from this earth without saying goodbye. Number one trauma. Then the case, it started to get through the media, and they had to relive it in the headlines. And then finally, up to this point, you could see. All right,
David, I'm sorry to have to cut you off, brother. We're running out of time.
Agreeing.
I'm real sorry. I'm Michael Ayala, folks. It's been a